Mr. Sai Deepak will argue now, or Mr. Manisha will argue this.
Look, the state has filed an intervention application seeking to respond to various petitions praying inter alia for a judgment and judgment declaring the marriage between persons belonging to the LGBTQI community as legally valid in the context of the Special Marriage Act in the Hindu Marriage Act. Lord, my Lord's Ladyship, I've had the privilege of hearing the arguments of the Attorney General, the Learned Solicitor General, and other counsels preceding me. I'll abide by the two regulations circumscribed by the Honorable Court, one being the time constraint, the other being not reading out any judgments. My Lord, I've formulated a few points, my Lord, for consideration of the Honorable Court, but even those, my Lord, I shall not be going into in detail. Let me just briefly
Can you
relate.
formulate that, Ms. Lavkumar? So we can
I
just
have
formulate.
formulated them, my Lord. I'll just briefly read it. There's only one point on which I propose to take the Honorable Court, my Lord. My 4 points which I have formulated relate to reading up, reading down, updation of the existing law, governing marriage, especially the SMA, to include non-heteronormative unions would lead to altering of the cultural edifice. You know, substantially already dealt with by the other councils. I wouldn't delve any further into it. Necessity for a wide consultative process and comprehensive deliberation by the legislation, but also has been extensively dealt with by the Learned Solicitor General. This is what I wish to further highlight, this and the next point. It is not a case of exclusion or prohibition, but a case of non-inclusion in a targeted legislation enacted with special aims and objects. And my Lord, taking this further from the deliberations, as transpired in the court yesterday, tracing any right of recognition by whatever name called, within or outside the framework of matrimonial laws would result in the creation of a new institution, dehorse the democratic process. My Lord, the inevitable ripple effect on numerous legislations, and my Lord, of course, my Lord, submissions with regard to the Foreign Marriage Act would get covered in the submissions already made with regard to the SMA. If time permitting, I'll make a 2-minute submission on that. My Lord, marriage as a socially recognized institution and the foundation of the Indian family unit, my Lord, I wish to submit that it is marriage between a man and a woman is at the core of the family. The Indian society is founded and organized around this concept of the family. My Lord, the rules of marriage continue to evolve, but they remain grounded in organizing of heterosexual relationships. My Lord, the interest of the state, considering the importance of this institution, my Lord, the interest of the state in regulating of marriage is, my Lord, lies in the overarching interest to preserve social order, ensure progression of society in a legitimate manner, and to regulate matrimonial conduct. In that sense, my Lord, marriage as a legal institution is not a private affair between consenting adults. It is a public act between two consenting adults who are then conferred a legal status by the state upon fulfillment of statutory requirements. My Lord, I then would point out that the SMA is part of a wider spectrum of all enactments relating to what we may be broadly calling matrimonial laws, whether in the realm of personal laws, whether SMA, whether FMA, all are heteronormative in structure. My Lord, I have excerpted by way of a table that all these laws carry certain features which would be considered as the core fundamentals or the thrust of the legislation. Namely, all of them refer to as heterosexual unions, all of them prescribe monogamy, all of them prescribe minimum age of marrying, and all of them carry prescriptions of prohibited degrees. They may vary from legislation to legislation, but all of them are uniform in that sense. My Lord, the fundamental of marriage, my Lord, before my lords, is a matter which has very serious consequences in terms of its depth and breadth, considering that my lords are examining not just the validity of an act, namely the SMA or the FMA. My lords are examining the very edifice of family institution, social structure, myriad of matrimonial enactments, and based on those myriad of matrimonial enactments, my lords, have succession enactments, divorce provisions, maintenance provisions, adoption and maintenance. So it's an entire regime which is regulated. And all of it which is based on heteronormative. So it is an entire regime. My lord, looking at the act in isolation, my lord, would not be possible, considering that it is all on the same platform. All heteronomous, all with these embargoes, all having regulatory nature, and all on the same platform. And built on this is entirely a regime of other enactments, and more importantly, social legislation, benevolent legislation, namely for Evidence Act 113A presumption, or Dowry Death presumption 113B, or Milord Dowry Death Act itself, or Milord Stridhan under the Hindu Marriage Act, Section 8. So there is an entire edifice which has been which is created around the institution of marriage.
You may read para 6 if you don't mind.
Please, my lords.
Page 11 of your note.
The rules of marriage continue to evolve, but they remain grounded.
Sorry, this is para 6 of page 11, social
Page.
institutions.
Brief note?
To the written submission.
Para 6. My
After the chart,
Please, give me my...
the chart which you have given,
Yes.
so 2 pages later, this is part of note sub-para 3.
Yes.
Yes, please read that.
Milord, the institution of marriage.
Yes,
The institution...
social institutions.
It's PDF 13.
PDF 13, yes.
PDF 13.
11. Printed 11.
13, Baba, come karo.
46 pages paper book.
Give me my compilation from there.
This is social institute.
Please. Social institutions consist largely of interlocking set of ideas that regulate or affect the way people actually understand and behave across interpersonal relationships. The meaning of social institution matters, and the institutions that bear it serve to structure our experiences and steer them in a particular direction. They define our goals, focus our attention on those goals, and direct us towards them. Changing the public meaning of a social institution leads to changing the institution itself. The concept of same-sex marriage is not within the percept of Indian personal law and legislation. Obliged. So, my lord, I have pointed out that the rules of marriage may continue to evolve, and they need must, but they continue to remain grounded in organizing heterosexual relationships. We have additional grounds for divorce being conferred. Over a period of time, my lord, even 21A seems to is enacted in the provisions of the SMA to ensure that now Hindu laws relating to succession, etc., would be made applicable. And they must evolve, but the normative structure still remains heterosexual. My lord, taking further from that, my lord, over and above the interest of the state in regulating, my lord, I wish to point out to the Honorable Court the argument at which, my lord, the deliberation rested yesterday was with regard to tracing any right with regard to cohabitation into Article 21 as expounded, my lord, in Navtej. So, my lord, Navtej has already granted them the right to cohabit physically, emotionally, sexually, unfettered. My lord, my submission is that contemplating tracing of any right, of any legal recognition of the right to cohabit would amount to creating a new institution outside, my lord, the legal framework. My lord, an endeavor was made, my lord, an endeavor was made to read the SMA in a gender-neutral manner. And the Honorable Court went through elaborately provisions as contained in Section 4C, provisions as contained in 4D. 4C was with regard to age, reading in a gender-neutral manner, age. For male, it was 21 years. Female, it was 18 years. as sought to be made applicable to gays, possibly yes, to lesbians, yes, but they are not representative of the entire community. My lord, LGBTQIA. So there are.
Could you
large
just,
number.
you've used a very interesting expression, juxtaposing the argument of the petitioners to the bouquet of rights.
Yes.
You call this as the sanctification.
That's right.
The sanctification narrative. Could you just explain this in 2 minutes? What do you mean by the sanctification narrative in the context of heterosexual relationships, heterosexual marriages?
My lord, my submission is that this principle of sanctification lies in the fact that the institution of marriage predated any legislation. Legislation recognize this social, cultural, pluralistic acceptance of this heterosexual union across societies, communities, and regulated it in a manner that was most beneficial to public order, sustainability, procreation, ensuring the best upbringing of children. And the regulation does not end at marriage. The enactment provides not only entry points, also exit points, the manner in which you exit, an organized manner, grounds for divorce, maintenance, who gets responsibility for it. So this is an entire genre, a regime created. Now recognition, the petitioners endeavored to look into this SMA as well as the FMA and read it in gender neutral manner. My lord, hypothetically, just taking the example of prohibited relationships under section 4D. My act, please. My lord, under 4D,
Thank you, Ms.
yes, no, my lord, would my lords, I need to make one important submission. If my lords be pleased to turn to my note, which I forwarded yesterday. I wish to hurriedly go through that. I'll take 5 more minutes. My lord, it's a 5-page note mailed yesterday.
Yes.
My lord, part 3, consequences of any declaration.
Sorry, Ms. Lavkumar, there's a 9-page.
9-page note. I stand correct. It's a 9-page note. I'm only going on part 3. That's all I wish to, my lord, read.
Part 3.
My lord, it would be page number 3. Page number 3, part 3.
Yes.
My lord, any declaration from this honorable court would have very serious ramifications. The edifice of matrimonial laws and ancillary laws are extremely regulated. Sans any regulatory regime, a judicial recognition would create serious social and legal issues. My lords, please to note, section 4 had a bunch of regulations, age prescription, prohibition related, prohibited relationships, bigamy, etc. Any recognition would become a law within the meaning of Article 141, and it would be binding on, my lord, the entire judiciary, and plethora of litigation would come seeking recognition. But dehorse this regulatory regime. Tomorrow, my lord, Navtej only talks of consenting adults. What about prohibited relationships? What about bigamy? My lord, there is no regulatory regime. Any recognition dehorse this regulatory regime would have serious consequences. I also point out, my lord, that entry 5, list 3 of Schedule 5, Schedule 7 empowers the legislature to enact laws with regard to marriage, divorce, adoption, wills, etc. This court, my lord, ordinarily would not arrogate it to itself the lawmaking prerogative. My lord, it is further submitted that the petitioner's apprehension is completely misconceived that the parliament would not look into it.
Yes.
My lord, the apprehension of the petitioners in seeking recognition of either marriage, a relationship akin to marriage, or by any name called, is misconceived on the ground that the legislature would decline to examine the concerns of the entire community, seeking legal recognition within the members of such community. And it is only this honorable court which would declare. You know, my submission, this is a circuitous route. Ordinarily, the honorable court would leave it to the parliament. It has various multifaceted dimensions, all to be deliberated, social consensus, a large number of debates, and conflicting views. Those adversarial views are important to evolve, my lord, a consensus on this issue. When to be done, how to be done. Rather than go to the parliament, the first endeavor was read into the SMA. when not fitting into the structure of the SMA, now seek a declaration apart from the SMA, which would have even more serious ramifications. And all arguments which are made applicable in the context of SMA would be equally applicable, my lord, in this context. My lord, would my lords now turn to para 20?
Thank you. I think we'll close it here, Ms.
Just one submission, my lord.
Yes.
By giving a declaration of the nature contemplated, my lord, this honorable court would unintentionally be foreclosing debates in society,
That we have.
foreclose the rights of society to
We have-
determine. And my lord, finally, my lord, such a declaration would hamper the genuine, organic, and sustainable change in society, which is reflective of the democratic ethos of the working of the Constitution.
Thank you, Ms. Mulnad.
My lord, I conclude by saying that, my lord, it's not a simple class of mere declaration of a result. It has very, very serious ramifications in considering the entire marriage regime and the ancillary social laws which are
All right.
involved.
Thank you, Ms.
Grateful to you.
Thank you.